And good afternoon, Nashville. It's 12:05 p.m. We are broadcasting live from our studios in downtown Nashville, just a stone's throw from the Tennessee State Capitol. In studio, the original All-Star panelist, Crom Carmichael, and say hello, Crom.
Greetings.
And we are delighted to welcome back to our microphones our very good friend, the Attorney General of the state of Tennessee, Jonathan Skrmetti. Welcome, General Skrmetti.
Thanks for having me back.
We're always happy to have you. A big win for the state of Tennessee. Just recently, our story from February 23rd, federal court bars NCAA from enforcing NIL, name, image, and likeness recruitment ban after legal challenge by attorney generals of Tennessee and Virginia. Congratulations.
Thank you. This is a big win. So this case involves student athletes' rights to get paid. And for a long time, the NCAA has really fettered their ability to monetize their name, image, and likeness rights in an illegal fashion. You've got a monopoly that is keeping kids, often poorer kids, from maximizing their ability to get compensated. And that's against the law. It's not right.
So you filed this case, you along with the Attorney General, Jason Miyares from Virginia, and it was assigned to the Federal District Court in Eastern Tennessee.
That's correct. And it's been less than a month, I think, since we filed this case, so everything's moved very, very quickly. There was a leak from somewhere that the NCAA was looking at the University of Tennessee as part of this effort to punish violations of rules that nobody knew about at the time. They created these rules after the fact and then sought to retroactively enforce them. And this is part of a broader problem where you have this giant organization taking advantage of young people, of high schoolers, of college kids, most of whom will never go pro, who have one shot to monetize their athletic intellectual property.
Yeah, and is this just the first step in this process? Describe how this litigation, is this the end of it, the middle of it, the beginning of it?
So what we did was get a preliminary injunction, which means for the rest of the case, the NCAA is enjoined from enforcing its NIL laws. And as part of that analysis, the judge has to see whether we're likely to win in the long run. And he said, we are likely to win in the long run. So Tom Mars, a sports attorney who's been pretty prominent on Twitter, looked it up, and there's something like a 14% chance that you lose the case after you get the preliminary injunction. So there's a high likelihood that in the long run, the outcome is going to be the same. And in the meantime, college students and prospective college students are protected, and they can go and negotiate and find what the market rate is without having to worry about this arbitrary oppression from an organization that's really behaved badly over the years.
Preliminary injunction comes when the judge says there's a likelihood you're going to win, and I didn't know it was that high, that only that low rather, only 14% of the cases where you get a preliminary injunction do you end up losing. That's pretty significant.
I like, you never want to take it for granted, but I like those odds.
Crom, you have a question?
Yeah, I don't quite understand. You refer to the NCAA as an organization, which it certainly is, but that organization, the decision that it made was made by individuals. If the NCAA has no right to try to limit lower income, let's just say lower income black kids from image and likeness, if the organization doesn't, can the individuals who tried to impose this, can they be held accountable by the people that they've harmed?
Potentially. There's a lawsuit against the institution. The damages are a little tricky to calculate, I think, and that's been going on in California for a while. My big issue is just stopping the harm. We need to give these kids a clear runway. We need to make sure, the biggest problem I have is the enforcement of the rules. It's arbitrary. The process is very opaque. And where NIL is concerned, the rules are opaque. Nobody knows what rules they were supposed to be following. They're not even really rules. They're guidance issued on top of rules that were passed years ago. And in that kind of environment, severe sanctions just are not appropriate.
Severe sanctions, excessive fines, these are all things that are prohibited from by the Constitution, right? The Eighth Amendment?
Well, it's the same idea. I mean, the problem, whether you're talking about a big organization, a big company, or big government, is the concentration of power in a way that leaves people ill-equipped to push back. That's why we fight the administrative state all the time, because you have this illegitimate concentration of power that's hurting people. That's why we go after Google, why we go after BlackRock. The NCAA is no different. And the same principle that animates all that other litigation is at play here. We need to protect people from the abuse of concentrated power.
If we could go back to this after the preliminary injunction, which was a big win for you and student athletes and the Attorney General of Virginia, that case now, though, is going to proceed. How long do you think that will take before there's a decision?
If we're fully litigating it, if they appeal the preliminary injunction loss, if we go through everything at the district court level, go through the Court of Appeals, there's a reasonable chance that the U.S. Supreme Court would take this up. They took up the Alston case a few years ago, which covered sort of the precursor issues to this. This is a very natural successor to Alston. It could be years and years and years. Now,
how often are preliminary injunctions like this appealed, and how successful are those appeals typically?
They're appealed with some regularity, and sometimes they're successful. There's a lot of discretion, though, for the trial court judge. Unless he really gets something wrong, the Court of Appeals is going to let this stand.
Do we have any indication as to whether or not the NCAA intends to appeal the preliminary injunction?
I haven't seen anything one way or another. Of course, they have the right to appeal. If they choose to go in that direction, we're happy to litigate. But I think they're looking at their options pretty broadly these days, because this is only one of a number of cases. It's probably the hottest one right now in terms of its effect on the NCAA's operations. But this is all prompted by the desperate need for change. They have not kept up with the law. They have not kept up with the times. And they really need to retrench. And if they're not going to do it, then either Congress is going to step in or the conferences will. But we need to have fair, clear rules governing college sports, and that's not where we're at right now.
When you say we're happy to litigate, it makes me so happy.
We're always happy to litigate. I hope that's coming through loud and clear to the people of Tennessee. I mean, we have no fear about taking it to court.
You know, it's interesting to me that you have this organization, the NCAA, which is ruled by a very small number of people, and they want to control the livelihood of all college athletes. They fight every step of the way to be able to keep college athletes under their thumb, no matter what their income, no matter what their status, no matter what their opportunities are. And I just wonder at what point in a corporation, when individuals in corporations act like this and harm others, sometimes they're held personally accountable for those things. And I just wonder whether or not these students who I guess now the students aren't being harmed because the NCAA can't enforce their plan. So students, until the case is resolved, ultimately, if the injunction, if the ruling stays in place, college athletes can they can take advantage, they can commercialize their likeness and image.
Right. And, the funny thing is, it was not that long ago, just a week, I think, since the NCAA said that you're not allowed to decorate the hotel rooms of prospects visiting the school. So they've been, someone called them the Homeowners Association of College Sports.
I love that. The Homeowners Association of College Sports.
Yeah,
that's crazy.
They've been nitpicking a lot of little things, and meanwhile, history is just moving on. College sports is moving on. I miss the days when it was just a bunch of people at their college stepping up to play for their school and get glory on the gridiron or wherever. But that hasn't been reality for years.
For a long time.
There's so much money in it.
Now, you realize that this is perhaps the most politically popular litigation in the state of Tennessee ever engaged upon by an attorney general of the state, right? I mean, everybody, the Tennessee Volunteer fans, Vanderbilt fans, everybody in the state says, take that, NCAA. this didn't go into your consideration, but that's been a side effect of it.
I will admit that people have been occasionally texting me memes that are utterly hilarious, but I also recognize that it will not be but a day or two before I do something that everybody hates, and I'll be right back in the doghouse in many people's eyes. That's okay. I'm just.
But you get so much benefit of the doubt from everybody in Tennessee when you take on the NCAA this way, and you beat them. Whap! I mean, that is a shutout, man.
It's a shame I'm not elected, because this would be money in the bank for that.
All right. When we come back, we're going to shift gears, although I love talking about you and the state of Tennessee beating the NCAA. We're going to beat somebody else in the next segment. ESG, here we come. We'll be back after this.